Yes, we can go.
Yeah, hello everyone. Welcome to day 7, session 9 of Summer School on Human Rights. So, today again we have Professor Dr. Antonieta Ilia. She is Associate Professor at Santiago University, Spain, and International Legal Advisor for many international organizations. Ma'am, over to you. You can start with your session.
Okay, so thank you very much for your patience today and for your interest to share our views on international law and international human rights law and environment. It would be a very generic introduction. Before I would like to ask you if you have any doubt in relation to our session of 7th June. Please feel free to present your doubts and questions. Like in our first meeting, I would like to ask please to our technical, our dear technical support to advise me when I'm at 50 minutes maximum, because since it is intended we are together for a maximum 1 hour and a half, I would really love to hear your doubts and questions, and so giving as much as possible time for that aim. So today it is supposed to try to reflect about one very central issue and one of the global challenge we have behind us nowadays. It is related to the relationship between human rights and environment, and then if we can affirm or not that we have increasingly the definition of a human right to a healthy environment as an autonomous right. To introduce you to such topic, I would like to start from one of our last point in the first session, because in the first session we had an introduction very briefly and very quickly about the UN human rights system, omitting, of course, the part related to, of course, for a matter of time, just for this, the part related to the fight against impunity for human rights violations and establish it in the framework of United Nations system. However, we talk about the human rights treaty body system. We talk about the political control over human rights respect and implementation through policies of law related to all human rights by states in the framework of United Nations. We said that such political control is exercised through the Human Rights Council and its procedures, special procedures established by the same council, which mandate is of each procedure is clarified by a specific resolution. If you remember, we said also that the special procedures term is used to include different mode of control, like an individual expert as a special rapporteur or special representative over a specific situation in a country, over a specific situation of human rights of a group considered in special need of protection, like children, like aged older person, and so on, or over a specific human rights situation all around the world. Maybe the freedom of expression, maybe freedom of religion, and so on. But such procedure can also be created as a working group, like in the case of working group on arbitrary detention, which is composed always by independent experts, but is a group. So we already said which kind of instruments they have to carry out their, in general terms, their mandate. We said they must answer and be in conformity, exert their function in conformity with a specific code of conduct, which include also to have no relationship with any government in terms of consultancies or multinational enterprises, and so on. Why I'm recalling that? Because very recently, exactly 1 year ago, on 8 October, for the first time, it has been created a special mandate holder, a special rapporteur on climate change and human rights. So you see the urgent need to at least monitor, study, and develop rules in relation to the impact that climate change can have over human rights, all human rights. This is just the last momentum of a very long process in international legal order and in the framework of UN, but not only in the framework of UN system. We are going to see that the very starting moment of the protection of human rights in relation to climate change and more in general environmental harms is also and especially the result of the efforts of regional mechanisms of human rights protection, and especially jurisdictional regional mechanisms of human rights protection. So that means that today we are obliged to make a reference both to the universal level and specifically to the regional systems, whether it is possible, in order to try to reflect about the impact of climate change of human rights, and on the other side, the emergence of a human rights health environment. And hopefully we have time also to mention such few modifications that national constitutions all around the world made in relation to the development. So the first initiative in relation to environmental modification and harms and their impact over human rights is in the framework of United Nations is related to the so-called Stockholm Declaration, which is right now celebrating its 50 years of anniversary. So you see that the matter of environment in the framework of United Nations is is really, it has been really central since so long time. However, in the Stockholm Declaration, the centrality is more dedicated not just to the protection of human beings, but in relation, this is my opinion, to the obligation and the action that states must take to preserve environment in order to prevent human harms. We must go, as I said, very rapidly, so we don't have time to spend all the day only in relation to the Stockholm Declaration, but I exhort all of you to have a look, and also to the recent additional declaration made in relation to the anniversary of the Stockholm Declaration, 50 years after. However, look at that process, protection of the environment. So it seems that originally the process of protection of the environment and protection of human rights are two sort of parallel lines, you know, with some point of conjunctions in relation, for example, to possible consequences of over human rights. But during such long time, that process apparently separated is going to unify it as mutual and interdependent processes, also at United Nations level. When we talk about protection of environment, impact of modification of environment over human rights, we cannot just mention specific general declaration over related to environment, but we must also take into account the work of General Assembly in relation to specific element in need of protection because of their immediate impact over human rights. I think, for example, to the right to water and sanitation. And the General Assembly Declaration of 2003, if I remember, or 2006, in relation to the right to water and the right to the need to guarantee the access to right to water as a fundamental and a basic right, and the need to preserve environment and to act to prevent any modification which can be an impediment to the effective guarantee of such rights. Just let me stop a moment about over that point. Because the relations between environment and human rights is not a generic one, it's a very complex one, as the regional jurisdictions on human rights clarified us over the years. And of course, the related responsibility of states in international legal order are also increasingly growing up in relation to the omission or the intervention they have taken to contribute to the modification of the environment and to climate change. So in the case of the right to water, as I already said in the introduction, you just think that water, the right to water does not exist in all constitutions. One of the most relevant example I used to mention is the Mexican Constitution, which in relation soon after the adoption of such a General Assembly declaration modified the Constitution, introducing an Article 4 as a fundamental right to water, and the obligation of states, the central state and the federate states, to guarantee access to pure water to everyone. The Constitution, the Mexican Constitution, is one of the leading examples of how a General Assembly declaration can impact the legal order at national level. If you remember, we said in our first meeting that apparently, from a formal point of view, a declaration of principle of General Assembly, we say that in relation to Universal Declaration specifically, but we can extend such reasoning to all relevant General Assembly declarations, like in that case, in the case of right to water. We say that independently from their formal non-binding status, they can also impact international legal order and modificate legal, national legal orders. And this is one of the leading example, the case of Mexican Constitution. And I think that in addition to the modification of the Federal Constitution of Mexico, also federate states modified their constitution in order to introduce at sub-state level such access to water, to pure water, as a fundamental right in each state. So this is one of the example at normative level, how it impacted in the case of right to water. But if we want to make a reference, an additional reference to the strengthening link between environment and human rights, we must go to the Rio Declaration of 1992. There, for the first time, it is declared in the Human Rights Convention, the Global Convention on Human Rights, it is declared the necessity of action to guarantee protection of human rights, preserving environment. And for the first time is the accent on the relevant link is in place in international legal order. Such global convention in 1992 is also important because he instituted the Office of High Commissioner for Human Rights 2 years after, in 1994, and soon after the tragedy and the genocide of Rwanda, because the international legal order and the human rights system at the level of UN see the inefficiency and the limitation of intervention and try to give an answer, unfortunately, in a second moment, so after the international crime having taken place, to create a system, as we talked in our first meeting on 7th June. From the until here, the UN system, the starting moment of UN system, but until nowadays, since 1992, many other advancements, advancements has been made. But if you remember, we said that the human rights system at UN level has been initially, from a normative point of view and from a formally legally binding point of view, sectorial, if you want, because we say that soon after the Universal Declaration of General Assembly on Human Rights, we had two important treaties on human rights, one related to civil and political rights, and the other one on economic, social, and cultural rights. Neither of them mention any reference to the link between environment modification and impact over human rights enshrined on each of them. Put the accent about that. In fact, the Declaration of Stockholm is of 1972, and the pact, the covenants are of 1966. So you see, we are still, we needed really more time to advance as a such process. But at the meantime, and you see how we cannot think as a protection of human rights, the protection of human rights as separate box between universal and the regional levels. At the same time, who is or should be considered as a pioneer in the definition between the link between environmental harms and human rights is are the institutions composing the Inter-American human rights system. You could have said the European one. No. For the European one, we must wait many years after. And we are going to see that each different regional system based the reasoning over different exigencies, because we should be bearing in mind that the regional systems are based not only on the geographical proximity, but also on shared common interests and priorities on the basis of constitutional traditions of states member of such regional system. When I talk about constitutional traditions, don't think, please, that I'm doing reference just to the elements contained into the single constitution of a given state. Not at all. When we talk about constitutional traditions, we are including all traditions, historical, legal, sociological ones, cultural ones, indigenous ones, etc. They are the comprehensive constitutional traditions, which define a nation. Of course, different in every country. So in the case of that's why we should start doing more specific reference to the Inter-American system. Possibly you don't know that, you ignore that the system, the Inter-American system, is composed by two organs: the Inter-American Commission for Human Rights, composed by independent experts, which is a quasi-jurisdictional organ and function as a pre-filter towards the Inter-American Court of Human Rights, which is the jurisdiction of the system. There is a very interesting dialogue between the two institutions, from my point of view, which grew up over the years, strengthening the same system. And one of the most important functions between many of the Commission, the Inter-American Commission, is to transfer the case to the court when it is considered relevant for the advancement of the protection of human rights into the region, into the Inter-American region. However, another element, another instrument, in addition, of course, to the individual cases against a given state member of the regional system, there is also the possibility to ask to the court. We don't have time to enter into the detail how we can ask to the court, who is entitled to ask to the court an advisory opinion of a relevant topic of interest for the advancement of human rights, but also to clarify what a state member must do to improve human rights situation in a specific case or in relation to a specific issue, like in the case of human rights and environment. Before to arrive to the advisory opinion adopted by the Inter-American Court of Human Rights in relation to the right to an healthy environment, which is of 2017, February 2017, where it explained with a very brilliant reasoning the relevant link between Article 26 of the Inter-American Convention and the protection of human rights, and how we must consider the right of an healthy environment as an autonomous right, fundamental to the effective implementation of all the others included in the convention, and especially the economic, social, and cultural ones. Why I said before to arrive to the advisory opinion? Because the advisory opinion is a sort of comprehensive expression of what the court did and the commission too through their respective case law and jurisprudence in individual cases against claims against a given state member of the regional system. Just to give some example in relation to not so late jurisprudence, but relatively recent. For example, you can take into account the case number 125, case comunidad indigenous community Yaquie Axa versus Paraguay of 17 June of 2005. And if you have a look, many of such cases in the Inter-American system are claimed by indigenous group or representative of indigenous communities or victims coming from indigenous communities. Why? As I said, every regional system gave priority to develop the link between human rights and the environment and the impact of the environmental harms in the modification of climate, starting from different urgent matters. In the case of the Inter-American system, we can easily say that the urgent matter was the protection of minority groups and especially indigenous communities. Their right over the right to identity. It is very interesting, the development that the court and the commission done over the definition of indigenous identity related to the land where they already live historically. So the right to property over the land because of historical stay in a definite place, the right to be heard in the negotiation over a specific action in relation to their habitat, and the right to decide over any possible action over that territory. So this is the centrality of the rights of indigenous people, the rights of indigenous people into the Inter-American system, prevailing over other priorities in the region. And that gave to the institutions of the system the possibility to develop the right to an healthy environment as a fundamental to the other rights enshrined into the convention, especially the right to health, the right to food, the right to the identity. This is very important. And please take into account this, use very quickly and shortly reference because of time, but hopefully we will have other opportunity to stop every step in another occasion. Because who took inspiration from that system is specifically the UN human rights system. So we say at the UN level, we have declaration and so on. At the same time, think that the regional system are doing their work. They are not stopping. So you see the mutual influence between the system as a circulation of norms, procedures, concepts. All of those mechanisms strongly contribute to the advancement, both at normative level and then at institutional level over the protection of human rights. On the other side, and at the same moment, also the step inside the European regional system, in the African system of human rights, is growing up over the link between environment, protection of environment, and human rights. The difference, one of the basic difference, as I said, is the starting point. In the case of Europe, I can say that the starting point has been the protection of private life, the right to the private life, the respect for the private life. In the case of the African system, to the contrary, has been the definition of development. No sustainable development is possible if a right to an healthy environment is guaranteed as a basic human right, fundamental to the effectiveness of right to health, right to food, right to life. In the words of the African Court of Human Rights. So you see how it working in some way over between the universal and the regional systems. So, but what happened? Someone can ask, but okay, you mentioned decisions. Most important at the regional level are decisions legally binding for states, parties to the covenants, respectively, Inter-American one, African one, and European one. Okay. The case of United Nations, we already reflected over the possible impact as a legal authority documents of a General Assembly declaration, but someone can say, okay, but there is any possibility of legally binding norm at UN level or decision at UN level, especially when we say that there is no mention in any or of the treaties of human rights of 1966, the two covenants, to the right to an healthy environment, to the obligation to respect the environment in order to guarantee human rights. However, if you already said one of yours, I think your colleague from South Africa last time asked the question about the failure of certain treaties to comply with the exigency of the society, and I already underlined that that's why it's so important, the reasoning of the institutions, jurisdictional one and quasi-jurisdictional one in the case of human rights treaty bodies at UN level, because they developed the link at UN level. That's their merit. So from one side, you have the political declaration, the political actions inside the Human Rights Council Truth Declaration, inside the General Assembly Truth Declaration, which have also their impact, as shortly we already seen. But there is also the intervention of the interpreter. Let me use the term, because to me, the Human Rights Committee is the interpreter of the covenant, is the first in the unique one, the principal one, not the unique one, because you know that according to the statute of the International Court of Justice, Article 38 of the statute, the court has a series of sources to interpret international law, and we can easily add also existing human rights conventions, which is the supreme judge, if you want, of the international legal order. But at the systemic level, in the regime of human rights protection, the interpreter of each convention is its treaty body. We say that, and I repeat. Let me do reference to the Human Rights Committee, which is the institution in charge of supervision of accomplishment with the obligation to protect civil and political rights. Pay attention, civil and political rights included into the covenant of related covenant of 1966. Civil and political rights, no mention to the right to environment, no mention to an obligation or any kind of link between such rights and the environment. So you can easily ask me, I don't know how you can talk about human rights and environment and what is the merit of the Human Rights Committee. Maybe you discovered right now that I'm a fan of the Human Rights Committee, right? For the improvements to the international, to the universal level it made, for the improvement itself it made in its function. It can be strange, at least, but to me, the Human Rights Committee is more autonomous and independent. There are certain regional systems, like in the case when it is called to interpret the law, has a vision over the text. It is called teleological interpretation. So the interpretation to reach the aim of protecting the human being. So I made the example last time in reference to the advancement, giving the example of the general comment over the right to fair trial, Article 14 of the Covenant. If you look to the edition of 2008 and the previous one of 1983. So you see the argumentation, the difference, the advancement, the effort, the autonomous, in the increasingly autonomy and independent from states. So the same in the case of environment. The same in the case of definition of obligation of states, liability of states for omission. So to not have taken action to prevent environmental harms and causing victims, causing violation of human rights. When we can see that, for example, but not only in relation of states, pay attention of that, also in relation to multinational enterprises impacting with their action over the environment and consequently provoking human rights, serious human rights violations. Few examples. The conclusion over the report submitted by Canada in 2015. The last part of such report, the decision report adopted by the Human Rights Committee, is strictly related to multinational enterprises, Canadian multinational enterprises, or multinational enterprises exercises in Canada, and their obligation to respect with environment, the use of natural resources, and at the same time, the obligation of Canadian states to supervise and do not be complicit and to prevent complicity with multinational enterprises in the violation of human rights as a consequence of modification of environment. This is the first. Remember that the other regional mechanisms were at work at the same time. And that, let me use that imagine that the expert of the Human Rights Committee opened the window and say, oh, there is another decision in the Inter-American Human Rights System. Let me see that. And then go back, talk to the other experts and say, hey, we must advance. They are coming, okay? So if you don't think to, it's a joke, just to say that apparently the mechanisms work without talking between them. But that's not the case, because the traffic of human rights standard is very high between the systems. And think that one positive thing is that sometimes few members coming from regional different systems add their constitutional tradition as defined before, legal, indigenous, and so on, historical, and so on, to the composition of the committee and to the reasoning. Don't forget that our tradition influence the interpretation, and put it together are the most rich and high level of protection we can give when interpret and all. And that's the case of the committee, and you will see visibly the advancement of the committee. Because it's not a region, the committee includes all regions of the world. under certain mechanisms of selection. But every region of the world must be represented inside the Human Rights Committee. And you see why sometimes the progress made by the committee are bigger than the European Court of Human Rights, for example. That's in my opinion, especially in relation to the link between human rights and environment. I see that I'm having a look to the time. I don't like to do that, but I think that we have just a few time. I asked to Arsha to confirm that, please.
Yes, ma'am.
I'm having a look to the time. I think that we have just few time to conclude.
Yes, ma'am, we have some time. You can continue.
Okay.
Yeah.
Thanks. But very quickly. And the Human Rights Committee, this is in the conclusion in relation to report. Remember, we said that, I repeat, that the obligation of a state to submit a report, annual report to the committee is defined by the joint lecture of Article 2 and 40 of the Covenant. But there are individual cases claimed before the Human Rights Committee where the Human Rights Committee goes a step ahead. Yes, there is. In 2017, notably Portillo, right, Portillo against Paraguay, the state of Paraguay. For the first time in an individual case, the Human Rights Committee go over the International Covenant on Civil and Political Rights, and first of all, recognized the accountability of state of Paraguay to have not take action to prevent the modification of environment because of which the victim lost his life. For the first time. And the committee, the Human Rights Committee underlined the obligation to secure the natural environment is a consequence of an obligation to guarantee the rights included into the covenant. In that case, the right to life, the right of a person to the personal integrity. So that decision, in my view, is important not only because of the link between civil political rights and the right of an healthy environment, but also because it is the state is recognized and responsible not only for action but also for omission. So to have done nothing, just to stay at having had a look about the situation without state action to prevent. Furthermore, in the same decision, the Human Rights Committee said, recognized the obligation in the wherever is possible to restore the initial situation. So before the violation of rights taking place, before the moment. So it means that this is one obligation. If the violation, so the modification of environment causing the violation is still in place, it must stop. and then try in the middle of possible to be back to the initial condition of the environment. An obligation to prevent and to repair. You see the important decision of the Human Rights Committee in that case. And the link between environment and environmental harm, climate change, and environmental harm causing impact on climate, and human rights on the other side. Of course, there is also mention also the human right, the Committee on Economic, Social and Cultural Rights made reference very recently over the link that we see between human rights and environment, but unfortunately, and especially between health and human rights, especially in that period of pandemic, but we unfortunately have no sufficient time to see that. But let me see also some important point, because we started saying that at the same time also the political control, diplomatic control has been created through the definition of the establishment of a special rapporteur on human rights and climate change. So this is really important because climate change is sometimes confused with, it is supposed that climate change is only human inducted, but in reality is a more complex phenomena. That's why it's so important to, and difficult at the same time, to define in the direct or indirect impact of an environmental modification, define the authorship of such environmental modification, and then to qualify the impact on climate and human rights. But it is really important, is an additional step ahead, the creation of such a special procedure in that way. Because also we are assisting at national level, not only to a constitutional modification, including like one of most recent one is the Italian constitution, introducing at Article 9 and Article 42 of the Constitution, the protection of environment, biodiversity and ecosystem as a fundamental constitutional principle, and the limitation of the economic activity, not only in relation, in terms of public security or public health, but also in terms of prevent any environmental harms causing impact on climate. This is a recent one, but it is also important that in many states we are assisting all around the world to an increasing number of submission of claims before national courts as the claiming the impact of climate change or stopping climate change, the human part provoking climate change, like gas emission and so on, because of their impact on climate change. So why I say that, because the question to demonstrate the causality link between climate and impact of a right over a certain right, over a certain group, not only an individual person, is needed sometimes when you are in a trial to have access to justice and effective access to justice, and in certain case to the claim must be considered admissible in that case. So many steps ahead. We have we assisted to many steps ahead from my point of view, at least at international level, in the human rights law, but it also true that more action must be taken. But I think that we are on the real on the good way. Let me conclude with this optimistic message, and looking forward for additional advancement. So I am going to stop here because I see that I overcome the 50 minutes as usual. And I will be very happy to receive your comments, views, and questions. Thank you.
If any participant has any question for the speaker, they can unmute themselves and ask the questions.
Hello, ma'am. Am I audible?
Hello. Yeah, I can hear you. Oh, sorry to interrupt you. Please introduce yourself and what are you doing, which level of study you are doing, okay? It's the best way to know us.
Okay, fine, fine. First of all, ma'am, namaste from India. My name is Saksham Tiwari. I'm a law student pursuing my LLB from Chhatrapati Shahuji Maharaj University, Kanpur. And as you have talked about the environmental aspect, so I want to ask you for some questions. Like we are moving towards talking about carbon footprints, and we are moving towards e-vehicles, and as well at the same time we are in the trouble of the disposal of e-waste. Like if you may know Mr. One of the actors from India, Mr. Rajnikant, one of in his movies, he has used the IBM laptop with the Macintosh version. So the RAM and the other specifications of that laptop during that time is for the requirements, but from further today's point of view, as everyone is aware that there are much specifications needed, like graphics card and other things. People use laptops for gaming as well as an other purpose too. So if we look for the if somebody has that IBM laptop at this time, it will be very hard to see that somebody is having that same. Nowadays, after 15 days, a new model of a smartphone is launched. People are aggressive and they want to purchase it. Somehow they don't purchase it instantly, but after that after passing all 3 or 4 months, they go with the making purchase. So it somehow increases the e-waste, like how we are tackling about this e-waste consumption. Ma'am, how will you in what's your opinion, like we are moving towards e-waste, but what is about the what is about e-waste if we are talking about e-vehicles? We are doing
yeah, please.
Are we doing our steps at the best stages, like we are having the disablement of these parts and sending to the service centers, they reuse it, but these are huge, like I think there is a huge gap between the disposal and the purchase. What's your opinion about the same, ma'am?
I'm not sure if thank you very much for your question, and I'm not sure I really understood your question. I will try if rightly understood. You are talking about the process to modification of a way of life, right? Using e-cycle, so new technological instruments to conduct our lives, is it?
Yes, ma'am.
Okay, so first of all, don't think that new technological apparel are not a polluter, not at all. At the same time, we have no way, at this point, we should also develop the mode to face against possible technological garbages. Let me say that, like battery of the cars, how you can recycle that. We should also think about that. So I think that we, unfortunately, we have not the crystal ball, and me, I'm not a technical engineer over that, but I can say that also the use of new technology can negatively impact our environment. So I don't think that because we are talking about talking online, we are not in such a way contributing to the modification of environment and the pollution of environment. That's not the case. Think, for example, I mentioned the question of recycling battery, but there is another one more present. How you create such battery? You need specific elements present in nature. So you destroy nature to grasp such resources for new technologies. You provoke conflict in certain parts of the world, like the Democratic Republic of Congo, where there are the certain zone where the minery is controlled by armed groups, using children to go in the minery to take such minerals useful for the battery. So we don't must stop over the fact that the solution to the prevent of climate change is new technology. No, is new technology humanized. So don't forget that we are humans, not technological robots or something like that. So, and I would like to quote a professor from Oxford, which is one of the most eminent sponsor of the humanization of new technologies and the use of new technologies. Is a philosopher of law, saying that in relation to the use of artificial intelligence, recall that artificial intelligence is created by human. It's up to us to decide right now what we would like to become, the master of artificial intelligence or a sort of subject dependent from artificial intelligence. Of course, that mechanism can also have a very good impact over the monitoring and the possible prevention of meteorological phenomena, for example, or to measuring the coastal degradation, just to go into other issues. But we must take into account that now we are using the computer, but to create such battery, remember that that battery comes from any part of the world where few elements are not always legally obtained. As such provoke sufferance in other parts of the world. So to me, the answer is not the technological advance, but the humanization of technological advancement. They are not separated. And in fact, there are many international organizations, including United Nations, but United Nations not so much, I must confess, maybe most that regional one, going through in that direction to try to regulate artificial intelligence and the economic aspect of artificial intelligence in order to prevent also violation in the middle of possible. Think also that is a cycle. Imagine that in a minery you must go to do an excavation for the minery and to have the element you need for the battery. So you don't take into account
You
the
are
environment.
indicating for lithium.
Sorry, lithium, exactly. This is one element, but there are also many others, especially for mobile phone. They are used for the microchips, for the most advanced phones in the market. So I hope that no exponent of any company of mobile phones is connected today. I'm joking. So, but I'm not accusing someone in specific case. I just say that sometimes, and this is the force that international institutions do to try to monitor such a situation, because in a place where you modify the environment because of the economic advantage, you are contributing to over the modification of climate too. You are in certain point also obliging people living in the same places traditionally to move, because they have no access to their traditional environment. They have no access to basic rights, to food, water, and so on, because of the modification of environment. It's all a cycle. And then those movement of person go to the cities, living in poor conditions, and so on. So don't think in a box, think out of the box. The phenomenon is more complex, it's not unique one, but there are phenomena related to each other which constitute consequences of each others. I'm not sure if I'm clear.
No, ma'am. I got my answer. Thank you, ma'am.
Thank you to you. Any other question or advice or opinion? Don't fear, I'm online. You know, I used to joke every moment, because otherwise we are obliged to stay. Obliged, of course, is not an obligation; is a pleasure. But to stay behind the screen can be tiring, you know. So sometimes joking it's better. So to interrupt the stay behind the screen. So Arsha, I don't know if we have any other question or in the chat.
No, ma'am, we don't have any other questions as of now. So I'll take this to thank
you.
So thank you so much.
Okay. I can't hear you.
And thank you so much to all the participants.
Okay. I can hear you so and so, but I think it's a problem of line connection. So if we are going to say goodbye to the next time, let me just spend a few words for our our students today, and it is always my pleasure to stay with all of you. And I'm extremely grateful for your patience and attention and interest. Let me also to thank you, people watching us live in YouTube, and who will have the interest and the passions to watch the records soon after. Thank you very much. Greetings from Spain, and enjoy the rest of the Sunday in the best possible way. Bye-bye.
Thank you so much, ma'am. And thank you, everyone. See you all in the next session tomorrow. Thank you.
Bye-bye.